Well, the U.S. Supreme Court kicked off its 2025-2026 term last Monday, and higher ed is squarely in the spotlight. Two headline-grabbing cases on transgender athletes are already on the docket, and legal experts say the real action may come from the court's lesser-known shadow docket, a fast-track process that's already led to major staffing cuts at the Department of Education and sudden reversals on research funding.
And that's hitting close to home. So we know the University of Utah lost a lot of research money, and it's stopping research just midstream even. So we have on the line with us Kelsey Dallas. She's the managing editor of the SCOTUSblog, and one of my favorite people to talk to about the Supreme Court because she can make it so relatable and understandable. What is happening with higher ed in the Supreme Court right now?
Thanks so much, Holly. Thanks for having me. Yeah, I found this article I read about this topic from Inside Higher Ed incredibly interesting because I think most of us are headed into the 2025-26 term thinking of President Donald Trump and how the court will reflect on his executive authority to fire people, to adjust foreign aid funding, to push forward his executive order on birthright citizenship, and lost in the shuffle a bit about the court's assessing these different policies was how many of the policies involve the world of higher education. So as you already were speaking about, there have been these emergency docket or shadow docket decisions about funding for research and then also staffing at the Department of Education. Both of those decisions will probably come back to the Supreme Court for a full assessment, what's called like oral argument or on the merits docket. And so it's going to be a significant term for academia. And that doesn't even mention other cases that are underway about free speech rights on college campuses or other types of funding debates about what strings can be attached from the Trump administration when they are trying to barter with schools to make changes to their campus policies. So I think that it wasn't until I sort of read some recent coverage from Inside Higher Ed that I realized, wow, this could be a really big deal for schools across the country.
Talk a little bit more about the free speech issues you're seeing before the court.
Yes. So I think that this bubbled to the surface when President Joe Biden was still in office. There were questions of how schools were dealing with protests over the fighting between Israel and Hamas. And the Trump administration has taken a harder line on that topic and said that schools really need to work hard to prevent any sort of unrest to the level we saw about 2 years ago. And that has led to some uncomfortable dialogue between college leaders of the Trump administration about what changes schools are willing to make, how the Trump administration can enforce the changes they'd like to see. We've seen debates between the Trump administration and Ivy League schools like Harvard about potentially revoking large chunks of funding, even beyond this question of research funding. And so it's sort of exploring a whole new world of the law. And the Trump administration is really pushing against some old standards to see what they are allowed to do.
So what's the time frame? Is this fast track thing going to be happening like in the next few months? Is this something that's going to play out over the entire term, which I think ends in June?
Yes, that's a great question, and it is not always a satisfying answer because the Supreme Court, when there is a request for in emergency relief, which is what you were referring to as the shadow docket, some people also call it the emergency docket or interim docket, that could happen basically any time. Like the Trump administration or a school could come to the court and say, we really need your help, put this decision on hold because it's very much harming us. So don't make us make this change to research funding or make this change to campus policy while this ongoing lawsuit plays out. So that can happen at any moment, and the court generally acts on those types of requests within maybe 2 weeks or a month or 2 months. With these broader questions, like if issues about cuts at the Department of Education or the overall question of the Trump administration taking away funding for health research projects, if that gets appealed to the Supreme Court and the goal is to have oral argument on it, that can take months between the request being made and an actual argument session taking place. And so on Friday, the court just took up a criminal case, and they actually won't hear argument on it until January or February, probably. And so if you get these higher education cases appealed later this year, they might not even make it into the 2025-26 term. So it really is a strange timeline, especially if you have stakes in the debate and feel like it's very urgent.
One of the other hot-button issues we're going to be talking about is presidential powers.
Yeah.
What is the president's ability to fire, quote unquote, heads of independent agencies? Kelsey, what do you see there?
Yeah, those are cases where, similar to these higher ed ones, they were originally in front of the court on the shadow docket or interim docket. The court, in the case of the FTC commissioner, Rebecca Slaughter, allowed her to be removed from office. But technically that is a temporary decision because they haven't considered sort of the broader underlying questions, and arguments will take place on that. And that's where they're sort of determining how much authority the president has to fire, remove leaders of what we previously thought of as independent agencies. In some cases, it might be a question of whether that removal can take place at all. In other cases, it would be what type of reasons the president would have to have for firing someone, like what would a cause of firing look like. And the other big one that folks I'm sure are following is the president's authority to remove Lisa Cook, the Federal Reserve governor. And that's interesting, where it came up as an emergency request from the Trump administration, hey, we want to remove Lisa Cook. But the court actually said, we can't make a decision on that in the short term. We actually want to hear arguments just on that short-term request. So they're really rushing into that, and I think it's going to be January where they hear argument. And so I say that's unique because they haven't actually taken up the bigger question about the president's relationship with the Federal Reserve. They really are just hearing argument about the decision about Lisa Cook specifically.
We've got one more minute left. Talk about the Voting Rights Act. Last year, the court heard a case out of Louisiana about redistricting. My understanding is that's going to be coming up possibly this week.
Yes, arguments are scheduled for Wednesday. And so, as you noted, this will actually be re-argument, where the court had heard discussion, heard debate last term, and then decided that they weren't prepared to make a decision. They are now looking more squarely at when courts can order states to create new congressional maps based on race or addressing race. The question in Louisiana was the Louisiana legislature interfering with the rights of Black voters by not having a second Black majority congressional district? But then it was like, wait a second, if the Louisiana legislature creates a district specifically looking at Black voters, does that then become a problematic focus on race in redistricting? So if you're confused, you're not alone. It's a very nuanced debate where it's like, okay, we need states to be thinking about race as they do redistricting, but not thinking about it in the wrong way or overemphasizing it.
Wow. Thanks for joining us, Kelsey. We've been speaking with Kelsey Dallas, the managing editor of SCOTUSblog. And when we come back after the break, we're going to talk about tariffs. Woohoo!